If I may, Mr. Walker, to reply to that, one reason that your counteroffers today don't hold a lot of weight with me is the fact that we never demanded to their attorneys that we ask questions outside the realm of the Epstein investigation. That was never a thing. They have just made that up. So their dishonesty, we've already admitted one lie when they said this wasn't a lawful subpoena. That was in the letter from Bill Clinton and Hillary Clinton to me. They said this is not a lawful subpoena. It is a lawful subpoena. Does anybody disagree with that? It is a lawful subpoena. So, number two, we've never asked to ask questions outside of this. And I'll give you an example. When we were negotiating with Hunter Biden's attorneys, or judiciary was negotiating, we agreed when Hunter Biden came in to talk about the Biden influence peddling and the money that they were receiving from foreign countries, we wouldn't ask about the stuff on the laptop. We wouldn't ask about the stuff in the suspicious activity reports about human trafficking and other things with Hunter Biden. We only asked about the influence peddling, which was what the investigation was. And it's been the same with the Clintons. So if their attorneys are trying to spin out with the media that we wanted to talk about Monica Lewinsky or anything else, that is not true. All we want to talk about is Epstein. That has always been the deal. And for them to say otherwise is a complete 100% lie by the Clinton attorneys.
Well, I'm glad to hear that, Mr. Chairman, and I'm glad that the Clintons have agreed to have the conversation transcribed. So it seems to me that the only remaining barrier of the barriers you have identified is you don't want to go to New York. And from my view, this investigation
I'm going to New York this weekend. That's not a barrier.
Go to the moon. Let's have the conversation. You can do it.
Chair recognizes who's next. Ms. Stansbury.
Thank you. Honestly, I just want to get some clarification because I've heard so many different things here this morning. So, Mr. Chairman, you just said you're willing to go to New York. In fact, you're going to New York this weekend. Is that correct?
The committee has released the emails, so
no,
you can see the communication between the staff.
I'm not trying to be difficult. I really just want to understand. Are you willing to go to New York to conduct this interview and deposition? With
the committee, with the staff, it's not going to just be. We have negotiated this for 5 months, Ms. Stansbury.
No, I'm just asking simple questions.
And you're all are speaking, and they've had 5 months.
Is the answer a yes? It sounds like it's a yes. My other question for you is, so it's my understanding that you guys have received both correspondence by phone, email, and from a written letter from the attorneys from the Clintons offering to do this on the record with you, with the staff, with the attorneys. Is that correct?
I wasn't paying attention to your question.
Okay, we're here pursuant to a motion you brought for contempt, and the claim is that you have made reasonable accommodations and that they have not been responsive, but they have transmitted correspondence to all of the members of the committee, including yourself and all of the members, basically including a letter from their attorneys stating that they have offered by phone, that they have offered by email, and they have offered in a written letter from both themselves and the attorneys to meet with you on the record with the staff to give sworn statements. Is that correct?
We have negotiated for
yes
5
or no.
You all are trying to create a false narrative. You've had 5 months. You should have gotten to the Clintons before the contempt vote.
All I'm asking you is if that's true.
And if they weren't losing public opinion, Ms. Stansbury, they would be defying this now. That's the only reason there's negotiations at the last minute.
But Mr. Chairman, I'm just asking. They
don't get to make the rules. We make the rules. The chairman of the committee, we make the rules.
But Mr. Chairman, is that the fact? That's all I'm asking. Is that factual?
Either.
Just to be clear for the public, his staff are advising the chairman to not answer that question.
This hearing matters because it puts a spotlight on a basic but powerful question when Congress issues a subpoena. How hard should it push to enforce it, especially when the witness is a former president? The debate is less about politics and more about time, authority, and whether Congress can actually get answers before an investigation runs out of runway. The exchange unfolds during a House committee meeting reviewing how to proceed with a subpoena issued to former President Bill Clinton. The subpoena is connected to an investigation involving Jeffrey Epstein and seeks testimony limited to that subject. Committee members are divided over whether to escalate to criminal contempt or continue negotiations through civil enforcement. The chair opens by warning against any delay. He argues that moving to civil enforcement would almost certainly trigger court battles that could stretch beyond the current congressional term. Since subpoenas expire when a term ends, he says waiting could effectively kill the effort altogether. From his standpoint, the subpoena is lawful. It has been outstanding for months, and continued negotiation only weakens Congress's authority. The ranking member sees it differently. She says the goal is not punishment, but testimony. In her view, civil enforcement keeps pressure on the witness while allowing negotiations to continue. She stresses that members across the committee want answers and argues that rushing into criminal contempt could derail the investigation rather than advance it. The disagreement sharpens when other members weigh in. One member points out that negotiations have already produced movement. He notes that the committee has agreed to limit questions strictly to the Epstein investigation and that the witness's legal team has agreed to transcription of any interview. He suggests that committee leadership could travel to New York to conduct the interview, arguing that such accommodations are common and practical. Drawing on past committee practice, he explains that negotiations over location, scope, and format have long been part of congressional investigations, regardless of which party is in charge. In his view, criminal contempt is a blunt tool that rarely results in testimony, while negotiated solutions often do. The chair pushes back strongly. He rejects claims made by the witness's attorneys, saying the committee never sought to expand questioning beyond the Epstein matter. He reiterates that the subpoena is valid and says months of negotiation have produced excuses, not compliance. For him, enforcement is about preserving the committee's credibility and ensuring that no one is treated as beyond reach. Another member attempts to cut through the dispute by focusing on logistics. If transcription has been agreed to, she argues, location should not be a barrier. From her perspective, the priority should be getting testimony on the record, wherever it happens. The tension rises when a member presses the chair to clarify whether the witness's legal team has offered sworn, on-the-record testimony through emails, phone calls, and written correspondence. She points out that the legal standard for contempt is non-cooperation and questions whether ongoing negotiations meet that threshold. The chair resists giving a direct answer and emphasizes that the committee sets the terms, not the witness. Additional members side with the amendment, arguing that the discussion itself shows continued engagement. They suggest that civil enforcement remains appropriate when talks are ongoing and warn against escalating too quickly. Before the exchange ends, the ranking member returns to clarify 2 points for the record. She notes that earlier depositions tied to this investigation included questions beyond the Epstein matter, which explains why the witness's legal team pushed for clearer limits. She also reiterates that the witness has agreed to transcription and has restated that position multiple times. At its core, the hearing highlights a familiar tension in congressional oversight. Criminal contempt sends a case to the Justice Department. Civil enforcement asks a court to compel cooperation. One is faster but harder to control, the other slower but more focused on testimony. What the committee decides next will shape not only this investigation, but how future subpoenas are enforced when time, politics, and high-profile witnesses collide.